Verdicts and judgment, let's make it easy and quick. What's our final judgment rule? A federal court of appeals may hear appeals only from final judgments that dispose of all issues, leaving nothing for the court to do except what? Execute the judgment. Let's say it one more time. The federal court of appeals may hear appeals only from a final judgment. What is a final judgment? It disposes of all issues, leaving nothing for the court to do but what? Execute the judgment. Okay, so what's a final judgment? Summary judgment on all issues, not partial summary judgment, because there are still issues remaining to be decided. What's summary judgment? No genuine dispute of material fact. Movement is entitled to judgment as a matter of law. Final judgment. A default judgment is a final judgment. A dismissal with prejudice is a final judgment. A win on JMOL is a final judgment. Okay, now the harder stuff. What's not a final judgment? Okay, well, this is pretty easy. Denial of summary judgment. If you get denied summary judgment, that means there's a genuine issue of material fact and you're going to court. That's not a final judgment. Okay, mandamus review, also called a writ of mandamus or an extraordinary writ. What is this? We're within trial and the judge is seriously abusing their discretion, violating a duty, refusing to obey a court order. This is extraordinary. That is why it is called an extraordinary writ. So because the judge or whoever is abusing their discretion, that is not a final judgment, and you can petition a higher court for mandamus relief to tell that government official, do your job. Stop abusing your discretion. Stop violating your duty. That is not a final judgment. It is non-final. It occurs during litigation and only for a serious abuse of discretion by some government official or a judge. Okay, the interlocutory order doctrine. Interlocutory means not final, temporary. An interlocutory order is something that happens during the course of the litigation. It's not final and it is there to maintain the status quo. Okay, is it appealable usually? No. What are we usually talking about though? There's some things you can't appeal them unless they involve an injunction. Okay, remember you can't appeal a TRO, but you can appeal a preliminary injunction. So if we have an order, there's two situations in which an interlocutory order can be appealed. One, if it grants, modifies, or refuses an injunction, or two, it is a collateral order. If it grants, modifies, or refuses an injunction, or two, if it is a collateral order. A collateral order is something that is completely separate from the merits of the case. What's a collateral order? It's completely separate from the merits of the case. Here are our elements. It's an unsettled legal question. 2, completely separate from the merits of the case. 3, the parties are going to lose those rights such that, point 4, an order would be such that it would be effectively unappealable after a final judgment. Our interlocutory orders are generally not appealable unless they what? Grant, modify, refuse an injunction, or they are a collateral order. So we've got an unsettled what kind of question? Legal question. It is completely separate from the merits of the case, and the parties would lose, that's right, important rights, such that it would be effectively unappealable. Okay, one more time. A collateral order is something completely separate from the merits of the case. It is what kind of question? Unsettled, and it's a legal question. Parties are going to what? Lose those rights unless we allow them to appeal that collateral order, because it would be effectively unappealable after a final judgment. Okay, one more time. Not a final judgment, denial of summary judgment, mandamus review, writ of mandamus, extraordinary writ. Somebody's abusing their discretion, violating a duty. You can appeal that. An interlocutory order issued during the course of litigation is generally not appealable unless it's regarding an injunction, granting one, denying one, refusing one, or it is a collateral order. Collateral means it is totally separate from the merits of the case. We're allowing them to appeal it because the parties would lose important rights and it would be effectively unappealable after a final judgment. And it must involve what kind of question? An unsettled question.